United States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all.
We'll take note of the presence of all board members for this. And this is a hearing to consider challenges to provisional ballots as per the 2020 general election. Pursuant to the Pennsylvania election code, the board is required to convene for a hearing to consider all challenges on the canvas board on provisional ballots. Parties and challengers have been informed of the procedures involved with the hearing. I will ask County Solicitor Joshua Stein to quickly first.
The hearings will be conducted under the direction of the election. When possible, all challenges related to the same or similar issues will be consolidated and heard by the election board together. All challenges shall be made pursuant to the election code. The election board will not consider any challenges outside of those containing directly to the initial decisions to grant full, partial, or no credit to the ballot. The board reserves the right to preliminarily determine if challenges meet this threshold. During the hearing, challengers will have the opportunity to present the basis for challenges and evidence and witnesses. The election board counsel will be permitted to also question any witnesses presented by the challenger. The election board counsel will then present any evidence the witnesses challenger may question any witnesses presented. The election board shall not be bound by the Pennsylvania rules of evidence. All testimony presented will be stenographically recorded and a part of the record of the hearing. After the parties have a fair opportunity to be heard on each challenge, the election board shall announce the decision to hold or dismiss the challenge. The election board chair will state all decisions on the record. The decisions will not be reduced to writing. Any party aggrieved by decision of the election board may file a petition with the Court of Common Pleas, Montgomery County, to review of the decision within 2 days after the decision has been made. Any appeal brought to the Court of Common Pleas in the decision of the election board must set forth the objections to the election board's decision along with a request for an order reversing said decision.
Aye. The board will consider challenges in the following order. First, challenges to the decision to give full, partial, or no credit to ballot based on the voter selecting a issued mail-in or absentee ballot.
It's our understanding that this was likely to anyone who has additional ballot, whether access to the ballot or not, full credit or no credit, I can object. That accepted party that
Good morning, Commissioners. We're grateful for the opportunity to be here today. My name is Jonathan Goldstein, and I'm here on behalf of the Commissioner. We have an awesome responsibility today to get this right on behalf of the people of Pennsylvania. It's not lost on us, but on the other side of the world today, protesters in China are being beaten and having to go through all kinds of horror to assert the basic rights that we assert here today, calmly and peacefully. And we're grateful to be a part of that peaceful, collaborative process to make sure we get all the votes that should be counted. In that vein, in that spirit, I have worked very hard with your able-bodied staff who have really made an effort, a concerted, proper effort to help us get to the correct body of votes that ought to be challenged. Mindful of that, I would like to ask Mr. Stein perhaps to read into the record what we know about a large body of the ballots that were originally challenged, and now having collaborated, having spoken, having consulted, we're prepared to withdraw those challenges and move on to other batches of challenges that are more worthy of the board's time. Mr. Stein, can I ask you to read in what we will read for?
So the ballots at issue were ballots that were voted provisionally by voters who had requested an absentee or mail-in ballot. Issue being that if those folks had vote provision and yet also receive their absentee ballot by the deadline. In reality, any voter that sent back and received their mail or absentee ballot was given 0 credit. Thus, any provisional ballots that would be at issue here that would give it full credit would have been voted properly. There's no possibility of double vote by individual. Having explained that to the council, they brought us along.
Well, so now that we know that there's an insurance, now we have an insurance, now we have carefully examined the underlying processes that your very competent staff has engaged in to ensure there is no double voting in instances where provisional will pass. Under those circumstances that I outlined, we are prepared to withdraw the blanket challenge that was issued to those. With the proviso, you're not withdrawing it as to any absentee or mail-in that was subsequently corrected by provisional. These are the ballots that are the subject of Judge Brobson's order from the Commonwealth Court. We do leave our blanket challenge in place as we go.
As there are none of those in this act, that is only one where for not returned motion will be changed to the control of that one.
Okay, I will make a motion that all for a second. Thank you. Number 2, Seth.
Here you mean or here?
You want
You both need to speak up. Everyone's speaking.
Oh, he and I have that.
So, if you go to the end of your.
I just don't want to block it. Is that better?
All right. Number 2, challenges to the decision to award no credit to ballots for no reason to select it. Ballot section.
I believe that challenge was raised by also the Democratic side.
Good morning, Commissioners. My name is Tim Ford, and I'm the solicitor for the Montgomery County today. I'm joined today by Beth Preston, who is my co-county counsel for the Pennsylvania Democratic Party's elected members for the Montgomery County. Commissioners, the Pennsylvania Democratic Party believes that every valid vote must count. As we've seen from the list of challenge provisional ballots, not only are there a lot of provisional ballots this year, nearly every provisional ballot is challenged. Most of these challenges were provisional ballots cast by voters who even so much as requested a mail or absentee. These frivolous challenges were just properly withdrawn. Many of these challenges were made by out-of-state observers with no understanding and no appreciation of Pennsylvania law and no empathy for our families, friends, and neighbors of any political affiliation here in Montgomery County. As an illustration of, frankly, the abusive process that took place during the 6 days of provisional ballot review, we have available as a witness Jennifer Maslow, the judge of elections in Lower Providence County. Every provisional ballot in Ms. Maslow's precinct was challenged because the Republican observer believed her signature on the provisional ballot envelope looked too much like an X and not enough like a real signature for their non-expert. Ms. Maslow came here today to offer samples of her signature to ensure the provisional ballot from her precinct count. Democrats, on the other hand, challenged the initial determination of the provisional ballots that were not going to be counted because of mistakes made by the judge of elections, not the voter. He believed that the right to vote and the right to have your vote counted should not be denied because of someone else's mistake when you did everything right. That is the basis of the Democratic Party's challenges to provisional ballots, giving no credit to the judge of elections mistake.
Our challenges generally fall within two categories. Number one, the judge of elections failed to check a box for reason for ballot. And number two, the judge of elections or the minority inspector failed to sign the outer envelope. Both of these items appear under a darkened line on the outer envelope, underneath which says, for election officials only. Voter Services made the initial determination that these ballots should not count. That is not the law. Instead, the statute, 25 Pennsylvania Statute, Section 3050, provides that the elections board, quote, shall count the ballot if the county board of elections confirms that the individual did not cast any other ballot, including an absentee ballot, in the election. The statute further provides that a provisional ballot shall not be counted if any one of 6 reasons is present. The judge of elections' failure to mark the reason or sign is not one of those 6 reasons. Instead, the statute provides only that this information is supposed to be on the affidavit that the voter signs, not that it must be filled out for the vote to count. Montgomery County voters should not have their votes left uncounted due to election worker error. In a case rejecting an election contest, the Pennsylvania Supreme Court said, quote, the rights of voters are not to be prejudiced by the errors or wrongful acts of election officers. In a similar vein, Pennsylvania's election laws are to be interpreted in favor of the right to vote. As the Supreme Court recently reiterated in one of the cases interpreting our new election laws, it is well settled, quote, it is well settled that, although election laws must be strictly construed to prevent fraud, they ordinarily will be construed liberally in favor of the right to vote. Indeed, our goal must be to enfranchise and not to disenfranchise the electorate, end quote. In support of our position, we are prepared to call 2 witnesses today. Donna Kelly, a judge of elections for Plymouth 1-1, who will testify that voters who voted by provisional ballot but signed a poll book did not also vote in person, and Charles Taylor, the judge of elections for Lower Providence 3-2, who did not sign the outer envelopes of provisional ballots and will testify that these ballots should otherwise count. The board should rule in a way that enfranchises voters, not disenfranchises them, especially when the error is the fault of the judge of elections and not the voter. Thank you.
Good morning. I think for the purposes of moving through the agenda, while Mr. Ford has laid out a variety of issues that he would like to address, the challenges currently before the board, I'd like the board to focus on, and what I'll direct my attention to is the particular challenge where no credit was given to ballot envelopes where the reason box was not checked, or where a separate reason was written in instead of checking one of the existing boxes. Prior to voting provisional ballots, an eligible elector is required by the code to sign an affidavit, and as the code says, check a reason for the casting of a provisional ballot. The code does have a specific section that states that very clear enumerated reasons as to why any ballot would be rejected. While our board took a conservative approach to interpreting the code on our initial review, the arguments made by Mr. Ford this morning challenging those decisions are compelling, specifically in the fact that the envelope instructs the reason for requesting the ballot section to be completed by election officials at the poll and not by a voter themselves. And as to the case law that we cited, the standard that we should be using is construing the code as literally as possible to vote for whatever that should be considered. In light of that, and the argument for an understandable interpretation of the law, we don't necessarily have any sort of objection for the poll.
I am going to open that one. Second. Comment, question?
to my knowledge, within the code, there isn't any specific language that says if the election official fails to keep that section. If the council has other, share that, I welcome.
Mr. Dale, the only language to this point are, we're in 25 PS 3050, section 8.4, subsection 2. And that section sets forth the affidavit, the declaration on the ballot. All it says is prior to voting the provisional ballot, the elector shall be required to sign an affidavit stating the following. And it just provides what should be on that declaration. It does not say that a ballot should be rejected. And in fact, the statute goes on to say in section 8.4, paragraph 5, the ballot should count unless one of 6 enumerated reasons is present, and this is not.
Challenges of all two. Right, number 3, challenges to the decision to award no credit to ballots missing of signatures with the president on markings.
I believe the reasons that we've already stated also apply to the challenge. If you have to do it, but comment from the solicitor office.
Yes, and I think our response is generally the same as it was to, challenge the, put forth, second challenge. I do believe that, when we're looking at the signature section in the reason, there, there's likely a reason for a higher threshold here, but in the end, this decision here is still being made to just kind of vote, based on something outside of that voter's control. The Department of State guidance instructs that the voter must fill out their signature section on the provisional ballot in front of the judge of elections and the minority inspector. The judge of elections and the minority inspector will then sign and date the envelope after noting the ballot, and that is a instruction from the state agency. Is not necessarily any sort of legal effect on whether or not the requirement is the state recommends. Purpose of this requirement seem to be a verification that an election official actually witnessed the voter to be outside of the envelope verifying should be given the ballot to go out. I think it's the interpretation of the solicitor's office that some signatures should be present on one of those two lines, whether it's the judge or whether it is the inspector. Would be acceptable for the standards to be collected either one side. The generally that.
Great. I think it's a challenge. For a second.
So, Ms. Marva, are there any valid in this, input? Either of those?
I would believe that I don't have a particular number on that, but I would say that neither is and under this particular challenge, I think in the motion that the board is currently considering, where I'm missing the question, where the signature for the judge election for a minority inspector would be sufficient to not count, would also include, the signature from neither. The board did want to, consider a motion where they would find acceptable the signature of either minority inspector or the judge of elections. That would be one I would suggest.
We deal with the motion that's currently in front of the board. But Ms. Marlin, to be clear, it's not the fault of the voter. It's absolutely not the fault of the voter if the judge of elections or the minority inspector failed to sign this form. The voter, for all intents and purposes, has done everything that's required of them. They obviously, the fact that this ballot is in front of us means that they were given that ballot, they were allowed to fill that ballot out, and they turned that ballot back into the judge, who then kept it securely for the rest of the evening and returned it to our office to be part of the canvas of provisional ballots. So, everyone, the voter has certainly been given this ballot by the judge. The only wrongdoing here was on behalf of our election workers and not necessarily the voter. Any further questions?
Mr. Becker, could you very briefly, the 6 reasons why a ballot needs to be rejected?
Absolutely. Under 3050, subsection 8.4, paragraph 5, subsection 2, a provisional ballot shall not be counted if A, either the provisional ballot envelope or the affidavit is not signed by the individual, so that's the voter. B, the signature signed under the sections 2 and 4 of the declaration in front of you are not genuine or not executed by the same individual, so those two signatures don't match. C, a provisional ballot envelope does not contain a secrecy envelope. D, D and E both have to do with identification issues. If the voter was required to show ID in the polls and did not, and didn't show in time, and that deadline passed. And finally, subsection F, which is new, is the elector's absentee ballot or mail-in ballot is commonly received by a county board of elections. And that was the concern with double counting that Mr. Stein discussed in the very first objection before you today. So this batch of provisional ballots in question were all not signed by an election official. That's correct, right? They were either not signed by either election official or they're missing the signature of one of these two election officials. So either none or one of the two, correct? And how many ballots fall into this category? We have a number for this.
May I ask a clarifying question? So I'm just trying to make sure I heard you correctly. None of these ballots have no signature from an election official.
No. I believe that within the universe of these ballots, we do have some that lack the signature from either election official. And I think it's just to clarify again, it's the position of the solicitor's office and the recommendation from us to the board that if it's missing both signatures, we would recommend that vote not be counted for not having any signature in that line. If it has one signature, either the minority inspector or the judge of elections, our recommendation would be, or both, obviously, our recommendation would be that should be a ballot that is counted. But to clarify to your question, this batch does include provisional ballots that have neither the judge of elections nor the inspector's signature on it, as well as ones that are missing one or the other.
So if that is the case, we would agree with your able-bodied staff that a ballot missing both signatures ought not to be counted, and I would submit to the board that perhaps the question ought to be divided to handle those two separate universes. One universe where a single election official signature is missing, and a second universe where both signatures are missing. In effect, where we have no sense that any election official reviewed that provisional ballot once it was completed by the vote.
I would also add that should this be appealed to the Court of Common Pleas decision, it would certainly be more expedient to have those separated up.
And can I just respond to Commissioner Hale's question? It's just over 300.
In the whole universe, not the divided.
Once again, can a voter get this provisional ballot without getting it from
an election official.
So the only way they would get this provisional ballot and then put it out and have it returned back to us is if it came from the election official at the polling place.
All right. I'm happy to separate the two motions for expedience of it's going across the street there. So I will withdraw the motion, and I will make a motion that we will uphold the challenge for ballots that are signed by one or two of the election officials.
I'll second that.
Second. Any questions or comments on that? All right, hearing none, we'll move to a vote. All those in favor? Aye. 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 Okay. So that challenge is upheld 3-0. And now I will make a motion that ballots that are not signed by either election official should be upheld. Is there a second for that? All right, so hearing that there's no second.
Just to clarify that motion, it's to uphold that they will not be counted. Because the existing decision by the county was that these were not counted.
No, it was to uphold the challenge, which means it would overturn the decision of the county.
Yes, okay, just to be clear, yes, to overturn it.
Overturn the decision. Okay, so there's, so that motion fails. So then, it remains the same, so we'll move on. The challenge failed. Challenge fails, so we will move on to Florida. Challenges to the decision to give credit to ballots where the voter does not appear on the district register.
There's a point at which the weather services staff sends registration information to its printer so it can print the poll books. In our case, that was 6 days after the deadline to apply for registration. So there are times in which someone, a voter, will timely apply for registration and is validly registered to vote in the county, but won't be in the poll book. And that's one of the reasons we have provisional ballots for those types of situations. And it's our policy that when the provisional ballot comes back, we check their registration. If they're not registered to vote in Montgomery County, that provisional ballot is not counted. If they are timely registered properly in the county and otherwise eligible to vote by provisional ballot, that vote is counted. And there was an objection by the Republican Party to those provisional ballots to people who were voters who were subsequently found to have timely registered in the county.
So to be clear, I want to state back to you what I believe we agreed to, which is that after our initial challenges by our perhaps zealous but able-bodied volunteers who, like everybody else in this process, are just doing the best they can. After we properly logged these challenges, we consulted with the election board and the able-bodied staff and determined that these folks were properly registered. Everyone.
That's correct.
On that basis, we ought to withdraw that challenge. We now know that those folks are properly registered, and they should be in franchise. They should be counted. We withdraw. Okay. Thank you. Challenge is withdrawn. Okay. I will make a motion to accept the withdrawal of the challenge. Is there a second?
Second.
Second by Dr. Eckridge. Any more comments? Hearing none, we'll move to a vote. Are there any negative votes? Okay. Challenge is withdrawn. Number 5, challenges to the decision to give credit where the envelope is not dated or dated incorrectly in any section where it is required. The decision of staff was to count these votes. This challenge is being raised by the Republican Party.
So perhaps I could hear from the solicitor about what this universal ballot is with a little more of a full set of details. So I think it describes 2 universes, right? No date and wrong date?
That is correct. Anything that would fall under this is where a voter had filled out this provisional ballot and had either not filled in the date section or had used the incorrect date
for what the date section particularly was requiring.
How many ballots is this, please?
It's approximately 660.
Can I have a moment? Yes, sir.
For my last whether confirmed, this is in section 4.
This would be anywhere where we see a date required within this form. So where we see it in section 4, they ask for a date specifically. I believe this would also apply, well, the date of birth is an issue that I think is also going to come up with a later challenge. So, yeah, this is generally the date where it would be required either in section 4, and I believe it would also apply to the minority inspector and the judge of elections in the reason for ballot section.
Without any prejudice to our ability to later challenge this on the same basis in another year or anything like that, we'll withdraw this challenge today.
Okay. I will make a motion to accept the withdrawal of this challenge. Is there a second?
Second.
Okay. Any board comment? And are there any negative votes? Okay, challenge is withdrawn. We're on number 6. Challenges to the decision to give credit to ballots where there is a missing municipality or county information in section 2. The decision of staff was to count these votes, and this challenge is being raised by the Republican Party.
Thank you so much, Mr. Vice Chairman. In consultation with your staff this morning and over the last several days, we got a better sense of what this universe of ballots consisted of. And it is my understanding from your staff, and I would like them to perhaps put this in the record when I'm done speaking, that as long as enough information was provided by the voter to uniquely identify that voter, the ballot was counted. And we think that that is a proper and good standard, and we, broadly speaking, intend to use that standard today with most of these challenges. That is to say, if we've got enough address information to uniquely identify a voter, let's count it. If we have information on that ballot where we cannot uniquely identify the voter, unfortunately, the voters failed to provide the necessary information to have properly and validly cast a ballot. So perhaps Mr. Stein can tell us about this universe and give us some assurance about the process they went through on the addressment.
Yes, so having...
And I would like to present testimony in support of those positions.
Terrific, yes.
Yeah.
That was, we've been speaking with staff, we have confirmed that is the process, but we do have witnesses prepared to testify to that. So we can listen to that testimony if that's...
Okay, sure.
If the testimony is consistent with what I said, I would be prepared to stipulate to it, unless the commissioners want it.
Yes, so, so in that testimony, we would, the witness would be that staff does ensure that there is enough information present there to properly identify the voter, so that if there, and it would not be counted if that information was not present. So that's sufficient explanation.
It does satisfy, and I would also point something out. I know we're being streamed on the internet and all that sort of thing, and tensions have run high around all these challenges. This is the right way, it seems to me, to do this. We raised a reasonable challenge. We consulted with your staff. Your staff is great. They're doing the right thing. Everybody's trying to do the right thing. We come in, we find out they did the right thing, and it gets pulled. It seems to me that's the right outcome, and I hope everybody who's watching understands that we're really trying to get to the right result here today. And by withdrawing challenges like this, I think we are reaching the right result.
So you're withdrawing.
I'm withdrawing.
I will make a motion to accept the withdrawal of the challenge. Is there a second?
Second.
Second by Dr. Arkush. Any vote comment? Are there any negative votes? All right, challenge is withdrawn. Number 7, challenges to the decision to give credit to ballots where section 2 is incomplete but contains sufficient information to verify voters' registered address. The decision of staff was to count these votes. This challenge is being raised by the Republican Party.
I think here again, on the same basis as the testimony we just heard, we're going to withdraw this one. We verified it. We saw that they did the right thing. We we withdraw this one.
You want to say the staff's doing a great job?
Staff's doing a great job. What you started?
Thank you. They don't hear that enough.
Say all weird. Maybe it's I'll make it weird.
I will make a motion to accept the withdrawal of the challenge. Is there a second? Second by Dr. Orkush. Any board comment? Hearing none, are there any negative votes? Hearing none, we will move on to number 8. Challenges to the decision to give no credit to ballots where it is missing voter signature in section 2 and/or 4. The decision of staff was to not count ballots with missing signatures. The challenge to count these ballots is being raised by the Democratic Party.
Commissioner Lawrence, I believe the only reason we made these challenges is to make sure that all voters with this problem are treated consistently. So at a certain point, the Republican observers were not making these challenges as to Republican voters, and we believe that every vote with this problem ought to be treated the same. And that's all we have to say on that.
Okay, in response to that, the code provides that the voter is to sign the provisional ballot envelope in sections A4 and then the affidavit section also in A4 section 2. I think that our position on this is the affidavit section is one where a signature is most certainly required by the voter, and in section 4, there's case law that says minus an attempt at fraud or any other reason, votes where something would amount to a mere irregularity is not enough to disqualify someone's vote. And I think the interpretation of the solicitor's office here is that a failure to sign in section 4 would amount to more of a mere irregularity than it would to anything that would necessarily disqualify that. I think our advice to the board would be that a single signature in section 2 is sufficient for these ballots to be counted. So if a signature is missing in section 4, these ballots would otherwise be okay as long as you did the baseline requirement of the signature in section 2 affidavit.
Then are there some ballots with no signature at all?
Yeah, I would say that we do have ballots that voters failed to sign in the affidavit section. And in that instance, the decision of our canvass board would be to not count those ballots if the affidavit section is not signed.
Question?
Are there any ballots that have no signature at all? In either spot?
Yes. I don't know the number on that, but there are indeed. I personally witnessed at least one.
And then there's some that have a signature in number 4, but not in number 2.
Yes, and then there are also ones with the opposite that is also true. I think that the affidavit section, that signature is certainly, that's where, they're making the affirmative statement about where they are registered and where it is most definitely required within the code, I believe, for that signature. I think as long as we have a signature in that section, as I said before, the lack of signature in section 4 would amount to something of an irregularity. And again, taking the interpretation that where permissible a liberal instruction of the code to allow for votes to be counted should be followed, I think we would be within bounds to accept ballots that have missing signatures in section 4.
Okay. I have a question. There's a disclaimer under section 2 and 4 that the voter must complete and sign in front of election officials before receiving ballots. So when they complete section 2 and 4, the voter, they're before an election official. However, the election official does not have to advise them if they're missing a signature line or a date line or anything of such?
We would hope that the election official would point out irregularities on site and allow for the voter to properly have it filled out. We obviously know, because we're here speaking about this today, that is not something that is done. But if, while I don't believe there is a specific requirement within the election code that puts an affirmative duty on an election official to verify that all of it has been filled out completely, it is certainly our policy to tell our judges of elections to do their best to make sure that when they're accepting these, that the voters fill them out.
So under the ideal circumstance, the election official would identify any errors or incompletion to the voter. However, it is clear that it's the due diligence of the voter to have everything complete, not the election official.
Yes, that is.
Ideally, we would like them to point that out, but
yes, yeah.
It's the due diligence of the voter.
I think that is a fair interpretation.
I'm going to, I'm sorry, may I ask a question? Sure. Thank you. So again, I just want to make sure I'm clear. You didn't count any ballots where there was no signature. Those were not counted. And are those the subject of this challenge?
I think the subject of this challenge are ballots with no signature, and then also ballots that have a missing signature. I think this might be a situation again where it would be appropriate for the board to split this into more of a section vote, one vote on whether or not to uphold challenges to ballots where no signature exists at all, and then one vote to uphold challenges to ballots where only a signature exists in section 2. Would that be sufficient? If you have a better way to word it.
No, I concur with your staff, who, by the way, doing a great job. Doing a great job. I think you got two separate universes. You have one where we get no swearing at all, right? That's a ballot we think you should be deferential to your staff, who's doing a great job, and not count those. If we have somebody swearing to something, I think we ought to enfranchise that person. And again, with no prejudice to my ability to later bring these in another date and time and place. But in this circumstance only, we would be comfortable with that, and we therefore suggest, as your staff has suggested, that the question be bifurcated.
So I'm going to make a motion to uphold the challenge for ballots where the voter signed section 2 of the affidavit section of it. Is there a second?
I'll second that.
All right. Is there any board comment or questions?
Yeah, I would just like to comment, so it's in the record. I believe this is a category where if the election code had mandatory signature verification, this wouldn't even be up for a challenge or discussion. So I believe it has to have signatures, and I believe it should have, the law says it should have 2 signatures.
All right, any other comments? All right, hearing none, we'll move to a vote. All those in favor say aye. Aye. Opposed?
Opposed.
So the challenge is upheld 2-1, with Commissioner Gale voting no. And I am making a motion to deny the challenge if there were no signatures on the ballots. Is there a second for that?
Second.
Second by Dr. Arkush. Is there any board comment? All right, hearing none, we'll move to a vote. All those in favor say aye.
Aye.
None opposed, so it is denied 3-0.
Mr. Chairman, I'd like to consider a motion where there is a signature in box 4 only.
Okay. So you're making a motion.
I will make that motion if that's all right with you.
Yeah, go ahead.
I would like to move that ballots that have a signature in box 4 but not box 2 are counted.
Okay, I'll second that.
And I want to offer some comment on that as one of the few non-lawyers in the room. When I look at this form, the big box is box 4 with the big S. And as I read these two different attestations above the two signatures. Again, in my non-lawyer reading, they don't sound that different to me. And so I think for the average voter, there's probably not a whole lot of difference between these two boxes. And I think that, as Mr. Ford has eloquently explained, the statute has consistently been interpreted by judges and justices on all sides, and we should enfranchise the voter as much as possible. I think I'm comfortable as long as there is a signature on one of these attestations that we should count those out.
Great. Thank you, Mr. Bill. Okay, we'll move back to a vote. All those in favor say aye.
Aye.
Opposed?
Opposed.
So 2-1. Now we covered that section, right? That's
Covered that one.
Great job.
All right, and we are up to number 9. Challenges to the decision to give credit to ballots where section 3 is not filled out, is missing information, or has a different address than section 2. The decision of the staff was to count these votes. The challenge is being raised by the Republican Party.
So thank you, Mr. Commissioner. Here again, we worked with your staff, doing a great job. We got to a place where we understand that standard I laid out earlier, which is if we have enough information here to uniquely identify a voter, it would count. The other thing that we want to make sure that everyone understands, that we understand, is that only needs to be filled out, section 3, if they've changed their address. So here again, to Dr. Arkush's point, this form is pretty confusing. And one of the things that actually your staff and I have been doing is keeping a list of some of this stuff. And after the election, we'll hope we can go back to the legislature and help them to help us, to help voters get this done a little easier. And we would welcome the opportunity to consult with the Democrats on this as well. But there's a lot of things like this that the legislature needs to hear from us on. And we're keeping a list. We're going to get it done. But for present purposes, as long as there is no change in address, we withdraw the challenge. And as long as the address was changed and we had enough information to uniquely identify the new address, we withdraw the challenge.
And that would encompass the entire universe of these ballots that have been challenged.
Okay. I will make a motion to accept the withdrawal of the challenge. Is there a second?
Second.
Second by Dr. Arkush. Any board comment? Hearing none, we'll move to a vote. Are there any negative votes? Hearing none, motion to accept the withdrawal passes. Number 10, challenges to the decision to give credit to ballots where voter does not print their name in both section 1 and section 4. And this is the decision of staff was to count these votes, and the challenge to these ballots is being raised by the Republican Party.
Thank you so much, Mr. Vice Chairman. Here again, in consultation with staff, we came to that same standard. If we have enough information to uniquely identify that voter, we think the ballot should be counted. If we don't have enough information, we ought not to, and it's my understanding that in every case, we had sufficient information to identify that voter.
That's correct.
Okay.
That being the case, we're going to withdraw this objection in the interest of enfranchising as many Pennsylvanians as we can legitimately enfranchise.
I will make a motion to accept the withdrawal of the challenge. Is there a second? Second by Dr. Arkush. Any board comment? Hearing none, we'll move to a vote. Are there any negative votes? Hearing none, motion to withdraw accepted. All right. Number 11, challenges to the decision to give credit to ballots where voter printed incorrect or incomplete information in the date of birth, phone, or email portions of section 1. The decision of the staff was to count these votes, and this challenge is being raised by the Republican Party.
Thank you, Mr. Vice Chairman. Here again, in consultation with your able-bodied staff, we came to a place where, first of all, phone and email, I think, are not required. I mean, they're there for the convenience of our staff. We're trying to gather information to contact voters, et cetera. That's great. But if we are able to uniquely identify a voter, this date of birth versus today's date issue is vexing, particularly I think with a lot of older voters. We don't want to be officious about it. if we can uniquely identify the voter, we have an affidavit that's, sworn with a proper date, we're going to withdraw the challenge as long as those voters were uniquely identified.
And that is the case with this entire universal challenge.
Thank you, Bill. I will make a motion to accept the withdrawal of the challenge. Is there a second?
Second.
It's a second. Any board comment? Hearing none, we'll move to a vote. Are there any negative votes? Motion to withdraw is accepted. Number 12, challenges to the decision to give credit to ballots where there are voter signature challenges. The decision of the staff was to count these votes. Signature challenges were raised by both parties.
If I might just step in, just on the front end of this on behalf of the county, just to set our standard and to see, if argument is raised by either party to what our standard for judgment here is. As it has recently been decided by the Pennsylvania Supreme Court, signature verification as it pertains to mail-in and absentee ballots is something that county boards are not required to do. The requirements particularly listed under section 3050 still do contain language around signature verification. Our policy in the office has been historically and continues to be that signature challenge is not challenge, but signature verification is something that we don't necessarily feel our staff are in a position to be able to accurately do, and in the interest of not disenfranchising a voter, our standard has always been that as long as there's a signature that is on in the signature line, that is an adequate standard for us to work with. And our policy that we would suggest, as far as the board is concerned, the challenges of this nature is that any challenge to a signature, as far as verification goes, that those challenges should be overruled based on the standard that our office uses for verifying, to the extent that we're required to, a signature of a voter.
And how many ballots is the university?
Approximately 25.
2-5.
Parties like to address?
The Democratic Party's position is that we just believe all ballots in this category ought to be treated the same. With an able-bodied staff that's doing a great job.
So, look, this is probably one of the hardest categories, right? I think ultimately the Supreme Court made a mistake pulling the signature verification process back on those other categories of ballots. It has long been the standard in this state, I think going back almost 50 years, that the matching of signatures is a sine qua non for whether a ballot was validly cast. That protects the voter. That protects the poor. That protects the people of low literacy. That protects the elderly from having a vote stolen. It's one of the only real safeguards that we have that is accessible and that everybody can understand. And fortunately, this standard for signature matching remains in place for provisional ballots. It's been removed for mail-in and absentees. And we agree with the Democrats that it should be applied uniformly and that these ballots where the signature doesn't match should not be counted to protect the voter from having their vote stolen.
For the record, I will clarify that this issue impacts the elderly voters the most, whose signature may have changed over time from when they first submitted their signature to the voter registration records that are kept by the county. So the elderly are at the most risk of being disenfranchised in this category.
We've also seen it with people of low literacy. So, not everybody signs their name 70 times a week, like lawyers do. So it's a tough issue, but it's one of the only safeguards we have for those folks.
And I just might add on top of that, from the county perspective, again, a lot of these signatures come from people who are signing them, when they're getting the driver's license on some sort of electronic pad, and that's not always going to give you a very accurate representation of your signature. And our standard here is our staff has found all of these signatures acceptable. I think I would present to the board that, you know, the duty is upon any challenger to a signature to show that the signature does not match, barring any sort of affirmative evidence that would show that here today. My recommendation to the board, it would still be to vote to count all of these ballots.
All right, I'm going to make a motion to deny the challenge. Is there a second? Second by Dr. Arkush. Any board comment or questions?
Yeah, I just have a couple follow-up questions. So to clarify, these signatures that are in question, it's compared to the signature on the provisional ballot with what's in the registry, not section 2 and 4.
That's my understanding. I think that question is better directed to the solicitor's office.
Yes, the comparison is to the signature that we have on file in the SURE database.
So the poll watchers had a view of the registry signature and obviously what was on the provisional ballot.
Yes, they were shown the signature that was on the ballot, and then our staff print out a screenshot of the SURE page that they referenced, and they were shown side by side the completed outer portion of the ballot next to the screenshot of what the SURE screen would look like.
And also to clarify, the original decision by the county was that these votes were counted.
Correct.
Now, does each party with the challenge not want these counted?
I believe as the Democrats, we only made these challenges knowing that those challenges were being made to non-Republican voters. So we would have made this challenge to treat all voters in this category the same. The Democratic Party would support overruling this challenge.
And does that go
for all voters?
The Republican Party as well?
It's 25 votes. We need a legislative fix to this today in the interest of enfranchising the most people we can. And in the spirit of ecumenicalism with the folks on the other side of the aisle, we would also think you should count these votes.
What was the Latin you used earlier?
Latin, God. I use so much Latin. It's hard to know. Sine qua non, yeah. Without what, there is nothing. Right.
Thank you.
But if I just understood that correctly, the Democrat Party would like the original decision to have an override.
I think we're saying
challenge should be overruled,
Yeah.
and the voter services office's initial determination should be what is counted here.
count the ballots.
That's right.
Okay, thank you.
So the motion is to deny the challenge. Both parties.
We actually withdraw, I guess we respectively withdraw our challenge.
We respectively withdraw the challenge so long as it's withdrawn for every voter in this category.
So I'm going to remove my original motion and I'm going to move to withdraw the challenge. Is there a second? Accept the withdrawal of the challenge for both parties. Is there a second? Thank you by Dr. Arkush. Any board comment? Hearing none, we'll move to a vote. Are there any negative votes? All right, challenge is withdrawn. The ballots are counted. 13, challenges to the decision to give partial credit to ballots where the voter voted outside of their district. The decision of the staff was to award partial credit and count the votes that were eligible to be counted. The challenge to giving partial credits is being raised by the Republican Party.
Background maybe here, if that can explain the issue here so that everyone understands that full credit, partial credit.
Sure. So when someone shows up to vote at a particular election district, if it is the district in which they reside and they have not already cast a vote otherwise, they're permitted to vote in person. In a certain instance, they can request a provisional if they were given a mail-in or an absentee ballot. If you were to show up in an election district in which you do not reside and you had not otherwise voted and you are a registered elector of Montgomery County, you would still be given a provisional ballot for that particular election district. And you would be able to vote the entire ballot, but upon counting that ballot, the canvass board would indicate specifically whether or not you could be credited
for every single race. If a race that is on that ballot is one that you are not otherwise eligible to vote in your own district, the vote for that race would not count. So as an example, I live in Royersford. If I were to show up in Lower Merion somewhere on election day and request a provisional ballot, statewide elections that I would otherwise be able to vote in my election district would count for me. Federal elections I would otherwise be able to vote in my own election district would count for me. Local elections that are particular to Lower Merion, even if I made a selection there, that vote would not count because I do not reside in that election district and I do not have the right to vote there. So that's what in essence, what a partial credit on a provisional ballot is for.
And that's in the code?
It states within the code that, yes, if you are a resident of the county and you vote outside of your district, you should be given partial credit for the races that apply to the district where you reside. In conversation with the Republican Party, I believe that will be withdrawing that.
Yeah, so we're going to withdraw that. That's frankly just a training issue. I think for people that come from out of state, that's kind of a hard one to get your mind around. So they flag these. We consulted with staff. We know the law, and the law is clear here. We're going to withdraw this one.
Okay, I am going to make a motion to accept the withdrawal of the challenge. Is there a second? Second by Dr. Arkush. Any board comment? Hearing none, we'll move to a vote. Are there any negative votes? Hearing none, motion is passed to accept the withdrawal of the challenge. 14. Challenges to the decision to give no credit to ballots where ballots were given no credit because poll book indicated they voted. The decision of the staff was not to count these votes. This challenge is being raised by the Democratic Party.
We believe on our observation of the provisional ballots in the voter services office that when this problem occurs precinct-wide, that's evidence that this is the judge of elections' fault and not the voter's fault. So to back up, a voter's signature in the poll book is voter services' best evidence that that voter voted in person. But if every single provisional ballot in a precinct was rejected, was given a no count determination by voter services because every single provisional voter in that precinct had signed a poll book, we believe that's evidence of judge of elections error in making provisional ballot voters sign the poll book. So when that best evidence came back to voter services, they made the determination not to count the votes because that person appears to them to be trying to vote twice. But if it happens in the whole precinct, that's a problem. And I have with me today a judge of elections for Plymouth 1-1 who did exactly that I'm prepared to call as a witness to at least rehabilitate the votes in Plymouth 1-1.
Mr. Marler, how many votes are these? And are they all in one precinct?
They were able to identify this was specific to the precincts that have been identified by Mr. Ford. I know it was Plymouth 1-1. Did you have an additional precinct where there was an issue like this?
There are additional precincts, but I don't think we have that information with us today. We are prepared to rehabilitate Plymouth 1-1 with additional evidence.
And may I ask, how many ballots is this for Plymouth 1-1 and how many overall, please?
And I don't have a specific breakdown for overall because if the staff found that somebody already voted, they just wrote already voted, and their vote was not counted then. They didn't specify whether it was in person or by mail or by absentee ballot.
Then our staff, when informed of Mr. Ford's intent here today to address Plymouth 1-1, went through what they had that is currently awaiting determination downstairs. We have 16 ballots that we've located that have this issue from that particular precinct.
From 1-1.
From 1-1, correct.
And I just don't think we have the data in the other precincts. I remember this issue coming up. we as Democrats were not initially challenging this if a voter already voted because everyone's vote should count once. But after going through an entire precinct and seeing this issue come up over and over and over again, you know, we had 48 hours notice for this hearing. These things move fast. We have to certify these election results. If we had more time, I would have loved to track down every single voter who had this problem. Again, it's not the voter's fault. This is a judge of elections that instructed a provisional voter to sign the poll book. But today we can rehabilitate Plymouth 1-1, and I'm prepared to do that.
And is that the 16th? Or is
That is the 16th from Plymouth 1-1. If you believe there was a similar issue as to another district, and you had a judge who could testify to that, if it would be, I don't want to speak for the board, because obviously I can't, but if the board would entertain this, if you were to have that witness who could testify today, I believe our staff would be able to go through and pull any one of those ballots out that might also have that issue. So if the board believes that the judge acted similarly on evidence that has been presented today, I think we would have the ability to make the appropriate correction in that regard too.
I don't think we're prepared to do that. They have a 5 o'clock witness deadline. We stopped recruiting witnesses and started preparing our case today.
Okay.
But
I'm
we
just
can
trying to
always do the right
understand. So
thing for
we're
Plymouth.
talking about 16 from Plymouth 1-1 now, but how many are there?
We
across the
don't,
board?
I don't know what that number is. I was just saying if there's, based on the party that raised the challenge, if they were aware of any more, just because, I just wanted to say, just because we don't necessarily have the ballots on hand right now, I don't know that would be a bar to, if you had the evidence to present, that would
And
be a
that can
bar
still
to
be
do.
remedied across the street.
Correct.
Okay. So you have the judge from Plymouth 1-1?
I do. If the board would like that testimony, I'd be happy to call her.
Yes.
We're prepared to stipulate to that testimony if the judge would simply identify herself and swear that what he said was true, Mr. Ford said was true, we could dispense with the testimony.
Yeah, I think from the county's perspective, if the judge is sworn in and will affirm that what we were told is the case, that would be adequate for us as well.
Mr. Saltese hasn't had the opportunity to swear anyone in, so that's he's doing a good job. Good job.
And so while they're getting the witness, can I just clarify, you said that, now it's more categorized by why they were rejected because the voter had voted. So in other words, you
Right,
could have
so-
gotten the mail
right.
ballot in.
Correct. I mean, I do have 16 that were categorized as having voted in person, meaning they signed the poll book, and also did cast a provisional ballot. But there are cases in which a mail-in ballot was returned, and they would be marked already voted. So I don't know if any of those that have been marked already voted for mail-in ballots were actually in this situation where they signed the poll book. Thank you.
Now we've done it, we used up all the paper.
Good morning, Ms. Kelly. I'd like to begin very simply. Where are you a judge of elections for which precinct? And how long have you been a judge of elections?
This is my term.
Great, thank you. We were just discussing whether provisional ballot voters in your precinct also sign the poll book. Are you?
Sounds like they did from discussions I've had.
Okay. So is it, just to clarify, it's your understanding that voters who surrendered their mail-in ballot to vote in person is the category of voters that also signed the poll book?
It was said in the poll book, not surrendered ballot.
Are you aware of any of those voters who signed the poll book also voting in person at the same time? Are you sure?
Bad company.
And sitting here today, are you aware of any reason why these provisional ballots of voters who also signed the poll book should not be counted?
They should.
Thank you.
Ms. Kelly, thank you for your service. You have a hard job. You have to make sure an election goes right, and everybody who shows up is suspicious and angry and weird about it. I appreciate everything you did to make it go smoothly. Mr. Ford asked you whether you were certain that everybody who signed that poll book and who got a provisional only voted once. You're certain of that, right? We have no problem accepting the testimony of this judge and having these ballots counted. Thank you, ma'am. Questions from the panel?
No, we have no questions. We are fine with the affirmation as stated.
All right. Ms. Kelly, thank you for coming in today, and thank you for your service as a judge of elections. Witness is dismissed. And I will make a motion to uphold the challenge for the 16 votes in Plymouth 1-1. Is there a second? Second by Dr. Arkush. Is there any board comment? Hearing none, we'll move to a vote. Are there any negative votes? Hearing none, the challenge is upheld. All right. Are there any other challenges not previously addressed? Right, hearing none, we'll move to the conclusion of this hearing. I will make a motion to instruct those members of the canvass board for the reconciliation and examination of provisional ballots for the November 3rd, 2020 election to award appropriate credit to all submitted provisional ballots based on the decisions made by the board at this hearing. Is there a second? Any comments? Well, I'll wait till the end on that. Hearing no comments, we'll move to a vote. Are there any negative votes? All right, it's done. And I will make a motion to adjourn the November 12th, 2020 meeting of the Montgomery County Board of Elections. Is there a second?
Second.
All right, and my board comment is I just want to thank the county staff who's doing a great job. Great job. The Republican and Democratic parties. I didn't think I was going to get to eat lunch today, but now I'm going to be able to do that. But seriously, thank you all for doing your due diligence, for working with our staff, and for moving this along. I think we enfranchise people today, which I think is the ultimate goal of this, is to make sure that people's votes count and we don't use the election code as a trap to try to trick them. So I thank you, both councils, for your time this morning, for your cooperation and keeping this moving along. Is there any other board comment? All right, hearing none. Is there any negative votes to adjourn? All right, meeting adjourned.